Any mention?
Please, Your Lordships. Your Lordships, I beg to make a mention of item number 5.
On behalf of?
On behalf of Dr. M. Singh.
Who's for the aside? What's this matter about?
This
The
is a
GST?
tax matter, Your Lordship.
Why? When?
Conduct.
After 2 weeks, Dr. M. Singh.
Lordship, please can take up in the first week of the September.
2 weeks will be, yes. First 6 September, yes.
Very much, Your Lordships.
Thank you, Lordship.
Yes.
Item number 1.
Yes, Dr. Saraf.
The petitioner was issued with a notice for cause for cancellation of the registration.
Yes.
And side by side below the registration was suspended, which you'll also find at page 25, dated 22/5/2026.
What is show cause for cancellation? Show cause 25.
My lord.
Where's the cancellation?
I submitted a reply.
Yes.
Well, cancellation has not been done. I submitted a reply,
Yes.
which you'll also find at page 26
Yes.
on 25/5/2026.
Yes.
Now,
Let them
nearly
dis-
3 months have passed.
We'll dispose it off. Let them. You within the certain
Well, the
period.
estimate.
I'll
Within
seek
one month,
instructions, Lordship.
4 weeks.
4 weeks, Lordship.
Within 4 weeks.
4 weeks will 4 weeks will too much, because my business is stopped, my lord. The registration is already suspended for 3 months. It should be maximum 1 week, my lord.
1 week.
Lordship, 1 week would be.
So you waited for so long. So Mr. Dr. Saraf, you waited for so long. So then we'll give them 3 weeks.
3 weeks, Lordship.
No, my lord. My lord, you'll also just appreciate, my lord.
Lordship, my learned friend is not willing to compromise here.
Yes.
My lord, I went to the office regularly, my lord, and my business is totally suspended. Either they reject or they accept. They have to, my lord, it's nothing, my lord, something especially there for them to do it. My registration is suspended. This is a serious effect, my lord. You'll also just appreciate, my lord.
We appreciate
1 week
that.
is good enough. 1 week is good enough, my lord, for them.
We'll pass orders, Dr. Saraf. Yes. We'll dispose it off.
My lord, my humble submission will be there, my lord.
We'll record all his submissions. All noted.
No, not recording, my lord, not recording it. I don't want anything recording, my lord. Recording, instead of that, something comes out from you. You'll also say, that is better. Recording my submissions will be of no use, my lord.
We'll show the effort that you've made to get it within 1 week, but the court's not inclined. We'll give 3 weeks. Yes. Yes. Next, man.
Grateful, Lord.
May it please, Your Lordships. Lordships, I'm craving leave of this Honourable Court to withdraw the present petition.
You've got instructions.
Lordships may grant us liberty to approach the appropriate forum.
Yes. Of course. Yes, MSK decrees Splendid Counsel for the petitioner submits on instructions that he may be allowed to withdraw this instant writ petition, however, liberty to approach appropriate authorities. Yes. Any submission from your side?
No, sir.
MS Emberchang Vice has no objection. Has no objection. Stop. Accordingly, on the prayer of the non-counsel petitioner, the petition is disposed of on withdrawal. However, with liberty to approach appropriate authorities as prayed is.
Highly obliged, Lordships.
3.
Lordships, this is the teaching. Lordships, this matter may be reserved for judgment. Lordships will be filing our written notes of submission, arguments in the course of the day.
We don't accept those. Sometimes it will come. What happened? Another matter.
Lordships.
We reserved it, maybe on the 9th of single bench,
Lordships.
and written submissions came the 19th of
Lordships,
next month.
Lordships, I undertake to file it in the course of the day, Lordships.
Yes. We listed on next Tuesday. You submitted. Have you submitted yours? Yes.
Yes, Lord. Yes, my lord. I have filed it.
Yes.
But I will revisit it and file a revised one below by Tuesday.
Yes, parties pray for additional 1 week to file its submissions. Praise our list next Tuesday positively, yes.
Highly obliged, Lordships. Lordships, the item 4 is also connected.
Yes, 4 list together also.
Six.
Terminacias.
So 6, 7 and 9, my lord, these are common issues.
Yes, so all rejoinder has been filed by you?
Yes,
all the
yes.
matters?
Yeah.
Okay. Yes.
So this is a common. So I will take up 9, serial number 9.
So you doing? No.
I am taking serial number 9,
Yes.
530 of 2025, as it is adjudicated and contested in the writ. And this may be treated as a lead case.
1 second. Let the file come. Oh, that's it. Where Dr. Mozika?
He's on legs before courtroom number
He's
1,
coming.
Lordship. The petitioner can start, Lordship.
Yes. Yes, Mr. Gupta.
Yes, my lord.
Yes.
So I am taking 530 of 25,
Yes.
serial number 9. So this present writ petition challenges show cause notice 26/3/25 and order original 2/9/25, which is expressly without jurisdiction, as it seeks to levy GST and compensation cess under reverse charge mechanism without any statutory authority. There is no law of levy GST and cess under the reverse charge mechanism for seized coal or incidental extracted coal. Therefore,
You mean to say that under these two heads of seized coal and incidental extraction, there's no provision in law
yes,
that allows
yes.
for levy of...
No, for levy of GST under RCM.
Yes.
So impugned proceedings are violative to Article 265, which envisages no tax can be levied or collected without the authority of law. It is a settled law, no levy can be levied by implication. Here no RCM notification exists, reversal mechanism does not exist, but levy was imposed on a wrong notification, 36 of 17, Annexure P95,
Let's see.
which is confined to seized and
So
confiscated.
now, firstly, on maintainability, you say because this action of the authorities or jurisdiction is
Yes.
seeking intervention. Okay, where's the impugned order? Page?
Page 95, Annexure 7.
Yes.
So, my lord, RCM, reverse charge mechanism levies based on section 9(3) of the CGST Act, read with notification 3617, instant
This is a
notification.
notification, this is a 17 notification regarding the... What is this? Page 95.
There is Annexure 7.
What is this?
This is notification, they are relying on this notification.
Okay.
That is I am challenging. Then this notification is not applicable for seized or incidental extracted coal.
Okay.
So here, table 3, just directly, used vehicles, seized and confiscated goods. old and used goods, waste and scrap. So here, my lord, confiscation is mandatory.
So no, now you're saying that under this head,
Yes, under this.
they have levied the reverse charge.
Yes, they have a revert charge. That in exercise of powers conferred by section 3, subsection 3 of 9 of the CGST Act, the central government on the recommendation of the council hereby marks the following amendments in the notification of the Government of India in the Ministry of Finance, Department of Revenue, dated 28 June 27 and published in the Gazette of India on 28 June 2017, hereby, namely in the said notification, serial number 5, and entries relating thereto following serial number and entries shall be inserted, namely 1, 2 and 3. 1 is serial number, 2 is heading of chapter, any chapter, description of goods, here is important.
Now see, so now you're coming again, you're saying it's auction of seized gold, correct? For which they are charging GST on you, correct?
Yes.
Now seized is here, used vehicle seized and confiscated goods. Will that coal not come within the meaning of seized?
No.
How?
Coal, here everything, here is 2 cases are for seized coal and 1 case, the instant case is for incidental extracted coal.
Okay.
This is not covered under this notification, both.
So you mean to say that in
Yeah.
2 cases, it was the
Yes, seized goods.
You bought the seized
Yes.
gold, which is an auction, correct? Right.
And in 1 case, the instant case,
Incidental mining.
incidental extracted coal.
That will be different from these 2 seized gold. And,
Yes, I'm telling.
yes.
So the confiscation is mandatory under this notification because only then goods are vested with the government. In the present case, there is no confiscation, only seized coal and incidental extracted coal. This is in the shock cause notice. Now, and the authorities had no jurisdiction to levy GST or cess under RCM on auction purchasers, that is impugned demand is without authority and violative to Article 265, which envisages that no tax can be levied or collected except with the authority of law. Now, the incidental extracted coal is neither seized nor confiscated goods as per this notification. Therefore, levy of GST and cess under RCM on such coal is without jurisdiction and unsustainable in law. This notification not apply. So levy is without authority.
Okay, what's the difference? What's the difference between seized and confiscated?
Yes, there is a difference. Section 67, Section 67 of the CGST Act deals with seizure. There is only a temporary measure. CGST Act. And confiscation is defined under Section 130. That is a final adjudication action after following the due procedure of law. There is shock cause notice, PH and order vigilance, etc. So upon confiscation, the ownership of the goods stands forfeited and vested in the government.
Section?
Section 67, seizure of the CGST Act.
Yes.
And section 130 is confiscation.
1 second. And 130 is
Confiscation.
confiscation.
So upon confiscation, the goods, ownership of the goods are vested to the government.
Yes.
Now similarly in other enactments also, that is under the BNS Act 2023, seizure is provided under section 106, 107, 117 is merely an interim custody pending trial. And confiscation is provided under BNS Act under section 119, 120 and 498. Confiscation is the final adjudication.
119?
119, 120 and 498 of the BNS Act. Confiscation provided.
Yes.
Under the Customs Act 1962, seizure is provided under section 110, that is investigation matters.
Yes.
And confiscation is defined under the Customs Act under 111 and 113. Is the final adjudication after following the due process of law. So, under section 67 of the CGST Act provides seizure, there is a temporary measure and it can be released, provisional release can be done under section 67 subsection 6 of the CGST Act. In case of seizure, provisional release may be done, under section 67(6), subsection 6.
Okay. Yes.
So this is the difference between confiscation and seizure under the various acts. Distinct. Seizure is one thing and confiscation another. Now, mere seizure, in these two cases, 67 and 68, two cases, goods are seized goods. So mere seizure, and in these cases, incidental extracted coal. So mere seizure in two cases does not amount to confiscation under section 130 of the CGST Act. Similarly, in incidental extracted coal also,
Yes.
without confiscation is not applicable. Now, incidental extracted coal is neither seized nor confiscated within the meaning of the said notification of 36 of 17. Therefore, levy of GST and cess under RCM on such coal is without jurisdictions, violative of principle of natural justice, and these two things. And illegally, invocation of section 74 deserves to be quashed and set aside. Now, my lord, next point is illegal invocation of section 74. This show cause notice was issued under section 74 penal provision that is not applicable in instant case. To overcome the limitation, department has invoked section 74 solely on bail allegation of suppression without any material establishing fraud, willful misstatement or suppression with intent to evade tax, contrary to the binding law declared by the Honorable Supreme Court in CC Bangalore versus Northern Operating System NOS and CBIC binding instruction 523 dated 13/12.
Okay, Mr. Dasgupta, please come to the adjudication order first.
Adjudication order.
What is the reasoning they've given?
Adjudication order is at page 140 to 41.
Okay, first we go to order and original before we come to adjudication order.
Order and original. I will go through.
Yes, where's the reasoning there? Yes. Page
54 to 71. 54 to 71, annexure 3.
Okay.
They have confirmed demand of at page 67. They have confirmed this by implication.
I confirm.
Order is page 667. Demand of GST amounting to 1 crore 1.
We see you are arguing section 74. So I want you to place
Yes,
order
yes.
original to show the reasoning. You see, you are arguing now on section
74,
correct?
yes,
Right.
yeah.
So now I want you to give arguments regarding the reasoning given on original and adjudicatory order.
Yes, yes,
Where's
yes.
the reasoning to show that it comes within the notification
Yes,
on
sir.
17?
Yes,
Because
sir.
your arguments based on that premise, correct?
Yes, yes, yes.
That 117 notification that talks about seized and confiscated goods, that definition will not cover the notice under section 74.
Yes, 74.
So
yeah.
argue
So,
on that.
Yes, yes. There says only one thing.
Yes.
I have not mentioned in the GST return. They say suppression. That means I have not mentioned the coal purchase in the GST return.
Right.
So this is they say it is suppression. My contention is that it is not suppression, my lord, because I was under impression that no tax is leviable. No tax is so declaration in the GST return not required, because that is only for taxable services. I am sure that there is no specific notification under section 9(3), that is RCM notification. So I am not liable to pay tax. Buyer has a zero liability to pay tax. It is the government who has to collect the tax from the buyer and deposit to the government. So I have got no liability. So I have not mentioned in the...
Yes, and you mentioned in your show cause reply.
Yes, yes.
Okay.
So
That's
this...
the reasoning. Yes, what is the reason? This concerns incidental coal, or is it seized coal, this particular case?
is incidental extracted coal. It is neither seizure nor confiscated under this notification, as per this notification. Incidental extracted coal. Incidental extracted coal means, my lord, there exists no notification issued under section 9(3), that is RCM notification, bringing incidental extracted coal or seized coal in absence of confiscation without the ambit of RCM. Accordingly, improved demand, GST and cess under RCM is exercised without authority and liable to be set aside. Now, incidental extracted coal,
Did you voluntarily deposit any amount?
I have deposited voluntarily, and that is case sufferance is there.
Did you deposit voluntarily?
I have
GST amount.
No, but
Then
my lord, even the voluntary payment does not permit the department to retain illegal levy. There is a case decision is there. Even though I paid 8 lakhs, that is liable to be refunded. Yeah, I will show. I am giving.
that gives them reason to proceed with the matter. Voluntarily also you have deposited the GST. Yes.
Yes, but by compulsion, they said you have to pay, we have paid. Now actually we are not paid. So there is a decision in the Supreme Court, ASP traders.
Not go to the Supreme Court right now. You argue case on
okay.
facts.
So that is
the law
that
will follow the facts. Yes.
that is does not permit the department to retain illegal levy. If it is
the law
illegal
follow the
levy,
facts, we
so
argue.
even if I pay, that is to be refunded. They cannot, the government cannot retain it.
Yes.
So incidental extracted coal arises during the lawful mining or land development activities without seizure, confiscation or vesting it to the government. Whereas seized and confiscated goods arises only after statutory seizure and final confiscation proceedings under section 130, resulting in vesting the ownership in the state. Difference between seizure and confiscation: seizure is provided under section 67 of the CGST Act, that is only taking temporary possession of the goods, and liable to be provisionally released under section 67(6). So in case of 130, goods are vested in government. In GST, seizure is provided 67, confiscation is provided under section 130. Similarly, other enactments also, separate provisions are there. I have already explained. Thus, mere seizure does not amount to confiscation. Now, section 75(2). So here, my lord, this section, sections, I was talking about the 74. CBIC direction is there. Section 74. Section. So, rejoinder affidavit, read petition 140 and 141. 140 and 141. Read petition 140 and 141, my lord.
Where are you reading?
That is the CBIC instructions regarding section 74. Page 141 of the read petition. There is a clear direction is there from the CBIC after the Supreme Court decisions in Northern Operating Systems Private Limited. Paragraph 3.2, page 141. That is regarding invocation, illegal invocation of section 74. Section 74 of the CGST Act.
See, please, Mr. Dasgupta, try to understand. Now you have to argue the matter like we will help you, okay? In the sense that we'll give you argue the points on certain issues that you have raised, not to go all over the place. We don't want you to refer section 24, go to notification, go to CBIC, come replace Supreme Court judgment, come to the act. No. If you want to assist the court, you can take it in point 1, 2, 3, 4.
Yes.
You first point you argue, find on
It is illegal levy.
No, first is you have to cross the hurdle maintainability. Because you have a resort to alter remedy, correct?
Okay, okay.
Why you have come here to invoke jurisdiction? That's point A. You argue that point, don't repeat that argument again. Then point B, as to why is 74 not attracted. And those reasons as to why, and then all your C's and confiscation will come. Then you can place relevant notifications and the definitions as why you say that, that 74 are attracted. And then you can also, that would come together, you can break it into the education orders and the order in original. What is the finding order in original? Whether you suppress, whether you voluntarily paid. So those are what reasons have you made with show cause and how have the authorities dealt with it? Correct?
Yes, sir. And
C, you can close the arguments, then you can break the other points. Or then if you go all over the place, very difficult for the court to collate also your arguments.
So now I am.
If you please, we'll give you one more opportunity. You please collate the arguments. Also, Dr. Mozika, you know that it's a very what do you call it? It's not very complicated.
It's only seized and confiscated, my lord. And there's a factual aspect, my lord, whether calls that was the incident.
So just that. So you can help the court. We will reduce the time needed for hearing, and also to render judgment.
Here, my lord, it maintainable.
Exactly. So
yes, I'm talking.
So please, I'll give another date. You prepare, right? And once you argue point A, you're not going to go back and repeat it again. You come to point B, you're not going to go to point C, you're not going to go back again. So when you prepare argument, just collate it, right?
Okay, sir.
Right. Okay. And we just spend time on it, like going all the countryside. Yes. And the prayer counsel for the petitioner posts this matter after 1 week.
Item number 8.
Three matters, yes. Please help us.
Okay.
Yes. You're an expert, we're not. Yes. Yes, it is how.
My lord, we have taken the instructions from the petitioner. Actually, as per their contention, since the authority is same and issue is the same, that's why we club to the orders. But actually, it's a technical mistake. We admit that. So, with due respect to the Honorable Court, I may be allowed to withdraw this petition. I will be at liberty to file a fresh after rectification.
You exceed the liberty to be given.
Well, it's illegal. It is there.
Again, the question of alternative remedy.
No, that is the separate issue. After the maintainability
that's pointed out by the
this
court.
This is not the case.
It's against 2 financial years. You challenge the petition here.
These 2 sides. That's why it's a technical mistake. So that should be rectified.
Yes, Mr. D. Sahu today praised that he will not withdraw the incident petition due to the technical defect that is apparent. Yes. The same objected to by Dr. N. Mozika. Matter stands disposed of withdrawal with liberty granted as per.
The liberty to file a case.
Please.
May I please, Your Lordship, I beg to mention item number 23, Lordship. 23, Lordship. Due to personal difficulties, Lordship.
20?
23, Lordship.
Yes.
Similar prayer for item number 28 also, Lordship.
Firstly, 23, who's there for the respondent?
We have other state, my lord.
You have no, all of you. What's the matter about?
Family pension, Lordship.
Only pension? Why you are joining?
Conducting counsel is not here, Lordship.
You are there. What is? It can be disposed of.
No.
Or there is a dispute between the petitioner
Who's
and
the
the
second wife?
Second wife.
You're the second wife. You have issues.
Yes, Lordship.
How many children?
2.
2.
Yes, Lordship.
Are they major or minor? Are you, who's drawing a family pension now?
No.
Who's getting a family pension? You are getting it.
No one is getting,
it's kept
Lordship.
in
Then
abeyance.
go for mediation. Why is it being kept pending?
It has gone for mediation also, my lord.
They're not agreeable. When do you want it? I could
After
put
1
on
week,
adjourned
Lordship.
pension matters. Yes.
1 week, Lordship.
After 1 week,
Well,
you'll be prepared. If Mr. P. Samadhi, you argued matter. Okay. Read it carefully. Court will help you also. Yes.
Lordship. Similar prayer for item number 28, Lordship.
This is also family pension.
Yes, Lordship. Same, Lordship.
Then why is what? It can't be disposed of.
Your Lordship, they went for mediation. Your Lordship was not settled. Second wife was there, Your Lordship.
Who's paying for second wife?
That one.
First wife, Your Lordship. She's the second
You're
wife.
the second wife. Who's paying? You're paying first for the first wife.
For the respondent wife.
Yes.
Is the family pension being taken by anybody now?
No, Your Lordship.
When did the person die?
On 8/4/2024, Your Lordships.
You may endeavor to dispose of after 1 week.
Okay, Lordship.
You kindly come prepared. Yes.
Highly obliged,
Much
Lordship.
obliged, Your Lordship.
Otherwise,
But item 30, my lord, behalf of the state. I am praying for a week's time, my lord.
so Dr. Amit Danish. What is this?
But this is challenging the appointment of the private respondent, my lord.
Who is the petitioner?
Petition is online, my lord.
Yeah, they're seeking time. You have any objection?
No objection, Your Lordship.
How long?
I'm praying for a week's time.
After 1 week. Yes.
Obliged, my lord.
Oblige, Your Lordship.
May it please Your Lordship. Your Lordship, I would like to mention item number 34.
34. Who's for the petitioner?
Jit Haba.
Have you informed him?
Already mentioned. Already informed him.
He's given his consent.
Yes, Your Lordship, this morning.
Is a pension matter also?
It's a family pension.
Yes. How long?
2 weeks time, Your Lordship.
Okay, but one family pension matter appears in hearing list. Please try to prepare it.
Yes, Your Lordship.
Dispose it off. Yes. This way, that way, yes.
Much.
Please, Your Lordship. Your Lordship, I beg to mention item 25 and 26. Your Lordship, in this matter, we have filed our rejoinder, but due to inadvertent mistake, Your Lordship, we did not serve to the MIDC and the AG, Your Lordship.
25, 26, what is the matter about?
Your Lordship, this is with regard to the pensionary benefits, Your Lordship.
They're retired.
Retired. No, Your Lordship, in 25 they are still in service. Some have retired, and in 26
When do you want it?
all
Who's
of them.
appearing for MITC?
MIDC, I am there, my lord. I have not received a copy of the.
Okay, as MSBF Karwanlam admits that the rejoinder's copy is not yet served on their respondents.
Respondent.
Is the matter be taken after?
2 weeks, Your Lordship.
2 weeks. 2 weeks, 20 or 26, yes.
Highly obliged.
Obliged, my lord.
Please, Your Lordship, I beg to mention item number 27. Conducting counsel is not keeping up well.
Not well.
Yes.
Who's the conducting counsel?
Mr. S. Pandey.
As reported that the conducting counsel on behalf of respondent number
7.
7 is unwell. This is matter after 1 week.
Yes, Lordship.
Yeah. On so on.
To mention item number 22, Your Lordship.
Lordship, Mr. Day is
Number?
on leave 22. Mr. Day is on leave, sir, Lordship. The sudden demise of one of our colleagues, elder brother, that's why he's on leave.
Your Lordship, last order says that district council is to produce the record or appear in person. No, neither they have produced the record nor he is present in person. Earlier also 3-4 times such orders are passed. They are simply ignoring the order, not producing the record, and last order says
22.
at least he should be present in that case.
There will issue bailable warrant of arrest.
Yes.
No,
Person.
The record was there before. The record was there before the mediation, Your Lordship.
No, the records were with you now.
During the mediation, the records were there.
With whom? With in the file.
No, Your Lordship, those are the different records and not the related records of passing the order 2510.
Have you filed affidavit?
Yes, I have filed the affidavit also.
The last date we said, Mr. So-and-so council praised me to file a small affidavit, bring on record clarification with regard to sale deeds which are in question.
That I have filed.
That's fine. Then you've got a copy of that affidavit.
Yes.
Yes.
Then all the matters pending you on records by the standing council for 112. Are the records available or not? No other records available with you?
No, Your Lordship, for now.
Those are the records.
Yes, sir.
During
No other records?
I don't think so.
No, there are records, Your Lordship.
No, but are they apart from the records that are already in the custody of the court?
Yes.
Whether there are any other records?
There is a record of passing the order by the assistant settlement officer.
Mr. D is coming tomorrow.
No, Your Lordship. Even tomorrow should on leave.
Next week, my lord.
We'll post it next week, Mr. Jindal. We will settle this matter. Yes, today, though by order dated C8 2026, this court had noted that it's expected that the records is available or a person should be present with the same. So, however, today adjournment being sought on behalf of Mr. S. Day, standing counsel for respondents 1 and 2 on account of bereavement. So, and with the matter, let's matter be listed on
Monday. Next week.
Monday.
Monday.
On Monday, yes, as a fixed item.
Much obliged, Lordship.
No, because it's bereavement is just poor junior. What we
No, at least the record should have been there. They are not there earlier also.
How many months you practice? How many months?
April I started.
Huh?
I started on April.
No, how many months have you practiced?
4.
See, he's doing very well.
Doing very well.
4 months practice. Yes. Yes.
Lord, I beg to mention item number 29. If this matter can come up next week, my lord.
No objection, Lordship.
Why is the repeated adjournment this matter?
My lord, today I am not personally ready with this matter, my lord.
Okay, 1 week.
Deeply.
Pleasure, Your Lordship.
May I please, Your Lordship? I beg to mention item number 32, my lord.
32?
Yes, my lord. For respondent number 6 and 7. Due to some
Who's one
personal...
of the 6? Acting same?
My lord, Darbar Shnong and the secretary.
I think too much time has taken.
This one got 10.
For 6 and...
Who's leading you in the matter?
Pete.
Mr. Nath.
No, Pete.
You're the person disturbing them?
Yes.
Are you still disturbing them or not? Not disturbing.
I don't have further instruction.
You
my
don't have
lord.
instructions?
Mm.
That's the case, correct? They were disturbing you.
Yes, my lord.
Then orders are passed with the court for maintenance of.
Yes, my lord.
Now they are no more disturbance.
Because of the presence of the police personnel, my lord, the law and order is matter is stable for now because of the presence of the police.
supporting them. But CM, his hands are tied.
No, Your Lordship. Your Lordship, if I may make a submission.
You've untied his hands.
Actually, we've never even tied his hands, Your Lordship. He has tied it himself, Your Lordship, saying that we have never given him a power. It's a general. He has the capacity as an acting CM, Your Lordship. He has the full power of the full-fledged CM, but he's refusing to act not only in this case, in other cases that are pending before this court, Your Lordship. We have never, they have asked them, they've never, even this court has directed them to file an affidavit.
Yes.
We have never given them any specific order, Your Lordship, verbally or otherwise, saying that you cannot act. There are so many Ilaka matters pending before this aim. He is refusing to act in all of them.
Then you put another acting scene.
Your Lordship, now the process of election is undergoing. He is the one who has, he is undertaking now to prepare the voters list. How can we?
What to do then?
He's refusing to act, not only in this case, Your Lordship, in all the other cases. Another
Mr.
matter is
Mata,
also
instruct
pending
your
before Your
client.
Lordship.
Yes, sir.
You say that the standing counsel, you tied your hands yourself.
We have never tied his hands, Your Lordship. They're making wrong submissions before this court.
MSPS Longbury today, adjournment has been sought on behalf of respondent number.
6 and 7, my lord.
On what ground?
Due to some personal difficulties.
On the ground of the personal security arguing counsel stopped. On the observation of the court that the acting's aim, no, not observation, with regard to the acting's aim. Yes, MSPS Longbury submits that he as an authority is to exercise his powers of acting's aim, and there's no hindrance on the part of the official counsel respondents in this regard. This is matter after
1 week.
1 week. Interim orders, we need to continue.
Highly
Supplementary list item number 1.
May it please Your Lordship.
Yes, number 1.
Your Lordship, I beg to mention item number 31. As the
Unending is mentioned, yes?
as the conducting counsel is on sanction leave.
And for the petitioner,
Who's
Lordship.
conducting counsel?
Magician.
Yes. When?
It's 2 weeks.
Freezing account? Freezing
Not
matter?
Lordship. Not regarding freezing account, Lordship. Lordship, petitioner purchased Ambuja cement from Guwahati, Lordship. And he did payment through RTGs in favor of Ambuja cement.
He purchased Ambuja cement?
Yes, yes, Lordship.
Okay. Yes, after 1 week then.
Not Lordship.
Yes.
Your Lordship, in this case, we are challenging the suspension order by the respondent number 1, who is the...
This is withdrawn and filed again. When
Yes,
the other
file
matter is
afresh.
coming up?
On Monday, my lord. 24th.
We'll sit together on Monday?
Yes, Your Lordship.
Yes, heard Mr. Majao. Yes, Majao counsel the petitioner issue notice. At the outset, learned counsel petitioner has submitted that the instant writ petition dealing with the suspension of the petitioner as
Petitioner as the honorary secretary.
Honorary secretary of the
Meghalaya Cricket Association.
Meghalaya MCA.
Yes, Meghalaya Cricket Association.
He is connected to other petitions which are pending consideration for this court and are due to be listed on Monday the 24th.
24th, yes.
24th. No.
Connected matters are on 24th, Your Lordship.
On Monday. On 24th. Yes, he prays that this matter also be taken up on that date.
Notice may be issued, Your Lordship.
Yes, yes. As Dr. N. Mozika
For 1 minute.
is present.
For number 1.
Of respondent number
1.
1, no further notice required. Mr. A. Kumar, on behalf of the
state,
number 2 is also present. Also, on behalf of respondent number 1, Dr. M. Mozika is present. Number 2, that clarification is present, so no further notice required for the 2 respondents. Notice to issue remain respondents in 3 days.
3 and 4.
Yes, on Monday, 24th.
24th.
Item number 2.
May I please, Lordship. Lordship, this is in regards to the subsistence allowances. Subsistence allowances. Subsistence. Yes, Lordship. Lordship, one connected matter is filed before this honorable court bearing writ petition number 352. Similar case, Lordship.
In this matter, Your Lordship.
No, Lordship. 2 different people.
Your Lordship, this writ petition is not maintainable because he is civil employee of the army.
He
is the civil employee of central government, so it will go to the central.
Lordship, before than this, Lordship, the petitioner has preferred writ petition in the year 2019 before this honorable court. On merit, Lordship, this matter was disposed and direction was...
Maybe that time there was CAT was not available.
No, Lordship.
Then
Then, Lordship, in the year
specifically this was without objection, it was admitted. So after
Then
that,
you withdraw and file
no,
reports and
Lordship.
have to
After that, Lordship, what had happened here is in the year 2022, Lordship, judgment was passed by this Honorable Court. Thereafter, they have complied with, and it was as per the order. They have to comply with the order within 6 months. However, they have complied after 9 months and issued their speaking order by dated 19th of May 2023, Lordship. Lordship, after that, then thereafter, Lordship, I have preferred one contempt petition before this Honorable Court, which was I have withdrawn that on the ground that there was a delay. Now I am preferring this
for implementation of the order of this court.
Lordship. I filed a
Yes, you
fresh
take notice.
Lordship. Yes,
That was the
Lordship.
Ghosh, when a
And
contempt
Lordship,
petitioner, you should notice, they're not.
Respondent 126.
Who do? This is not on behalf of
126.
On behalf of respondents 1 to 7.
1 to 6, Your Lordship.
Why controller defense account?
Controller defense account because last week was applicant problem was there, so
some problem was there. 1 to 6 is present, except notice. Stop. He, however, raised objections regarding maintainability. He permitted to place the same by affidavit. Yes. Or you don't need. Or you want hearing maintainability.
matters may be, Lordship, tagged with 352, Lordship.
As is submitted, that is it correct? 352 is not a matter pending which is identical and similar to this.
last question one came, Your Lordship, I did the same objection. So this.
Okay,
another.
You said when?
Any date, Lordship.
When 352?
It's fixed on 28th. 28th.
Yes, this matter on 28th before the orders. Yes. You make objection that they will hear maintainability. Yes.
Okay, sir.
Item number 3.
I don't think this matter recused once, I think.
Your Lordships have appeared in this matter for JHATC at an earlier point of time. In fact, Your Lordship as well as Justice Bhattacharya.
Is pending any other, this is a miscase in a pending second appeal, no?
No, this is an application for condemnation of delay.
Oh, yes.
This is with regard to a civil suit where the first appellate court had remanded an order of dismissal passed by the original court. So we are saying that the order of remand has not been passed in confirmation, conforming to the guidelines under Order 41 CPC. So as the original suit was filed with the respondent number 1, that suit came to be dismissed. She preferred a first appeal before the court in July. That first appeal was allowed with the consequence that the matter was remanded for fresh adjudication from the stage of framing of charges. And we are questioning that order of remand. I apologize, the stage of framing of issues. So we are questioning that order. It does not conform to the procedure prescribed under Order 41.
I don't know whether I can take up this matter.
The Mallots have appeared in one of the matters for the JHATC. In fact, Justice Bhattacharya has also represented the respondent number 1. So I'll leave it to Your Lordships.
Only Justice Dindo.
Although it's a pro forma respondent as a rate in the original suit, but there are reliefs, material reliefs sought against the JHATC.
Then better that yes, list this matter before any other bench or me.
Lordship.
But the name is very familiar. Rosila.
From the 90s, when this matter has been litigated. Obliged.
Item number 4.
My Lord, we have issued the reinstatement order and taking over is, my Lord, today. Taking over the records and the...
But why have you all along, why didn't you issued immediately as per the order of the court?
My Lord, we in fact, we received the certified copy of the contempt was filed and process was done. Immediate reinstatement was issued on Friday
itself. Yes, up to them. You want to press the contempt?
My Lord, I would like to press the contempt. My Lord will kindly see the order which has been issued.
Let them file a show cause affidavit. Yeah.
I have entered evidence for respondent.
Yes, you. I think you should. I think you. Against you, there's some materials as per that. That is official respondents. I don't know, but
half an hour, just half an hour before my copy was served. Just half an hour before today.
Why you didn't serve copy earlier?
Well, that appeared yesterday, my Lord.
Appeared yesterday, meaning?
I entered appearance only on the news, my Lord.
No, yesterday where?
Yesterday, this matter was here, Your Lordship, before my Lord. Now, there was a newspaper report, no copy was served, my Lord. On the instruction, I appeared just to obtain a copy. The copy was served only today morning.
And you will take it next week then.
Well,
you file issue cause. Yes, what Mr. S. Sen has entered appearance today on behalf of the respondent number 4. And as such, Notice the complete order respondent. Stop. Mr. Changresu, appearing for the respondent 1, 2, and 3, has submitted that the petitioner has since been
reinstated and taking over take place today.
Taken over office.
Yes.
Yes. Visit me as the petitioner insists on. This is a matter of then. Okay. This is a matter after 1 week.
After a week more.
For objections affidavit or
10 days.
10 days. Okay. Yes.
Obliged.
Otherwise, let's see.
Daily list item number 1.
Yes.
My lord, the pleadings are already complete, my lord. This matter relates.
Submit for prohibition today.
My lord, the non-payment of pensionary benefits to the family members of the petitioner.
Yes.
My lord, my husband.
Other side, you're there.
Yes, Lordship, I'm there for the respondents.
My lord, your lordship will kindly come to page 41, whereby I was asked to retire.
41.
Page 41, annexure 5. I retired on my husband retired on 31st of January 2016.
Yes. Yes.
And then my husband expired on 3rd of September 2020.
He expired on?
3rd of September 2020. Annexure 6, page 42 is the death certificate.
Annexure 6, okay, yes, continue.
My lord, as on this date, my lord, the petitioner has not received any family pension, my lord.
Till date?
Yes, my lord.
Have you made representation before that?
Yes, my lord, representations were made.
When did you make it?
Your lordship will kindly come to page 49, annexure 10. Last representation.
But you submitted all testimonials necessary.
My lord, all the documents which were available with us.
Yes.
Page 49, annexure 10. This was the last representation submitted by the petitioner.
31 or 30, 10,
30th
25.
of October 2025. And then this matter was also sent before the mediation also.
That's all.
Mediation.
What's the difficulty with
Lordship, here in this matter, Lordship, the representation submitted by the petitioner, Lordship, is after 5 years. After 5 years from the death of the petitioner, Lordship, of the husband.
He died in 2020.
Died in 2020.
Sometimes they're not aware, if they're uneducated and all, they don't know how to go about it. So you have to give the allowance also.
So, since that time, Lordship.
How old is the petitioner now?
My lord, the petitioner is, my lord.
When it was filed? She'll be 60 years old.
And
59,
he
2025.
did not join his last place of posting, sir.
That's already dead now.
Mauflang. He did not join his place of posting.
I dispute my learned friend's submission, my lord.
And there is no intimation or information whatsoever.
It's not a case of overstaying his service, correct? No.
No.
It's not a case of recovery of any dues, right?
Yes.
Then let's see your affidavit.
My affidavit, Lordship.
This is filed by 527.
5 by 527, yes.
What do you say here?
In paragraph 8, Lordship. Paragraph 8. That with regard to the argument made of 5 of the petition, the answering respondent submitted that his husband of the petitioner, after receiving the said transfer order dated 13/10/2008, did not join his place of posting nor submit his joining report, and without any intimation whatsoever, and the ground given by the red petitioner being illness, which result in inability to perform his duty from the year 2008. The answering respondent submit that a letter seeking explanation for unauthorized absence from duty was issued to the late husband of the petitioner, white letter dated 23/02/2011, but this office did not receive any official response or communication from the deceased husband of the petitioner, which led to the lack of information of this office regarding the well-being of the late husband of the petitioner. And paragraph and paragraph 16, Lordship, paragraph 16.
Yes.
Paragraph 16. That with regard to the argument made, paragraph 15 of the writ petition, the incident respondent has no knowledge or information of the same. At no point of time since the death of the husband in 2020 did the petitioner approach the chief engineer PHE or the executive engineer of the concerned division to seek clarification or request necessary action. Despite the
delay might be attributable to her, but then she is entitled to any your computation of family pension as admissible to him. But then is it a fact that he didn't go for duties after 2008?
My Lord, yes, it is there, Lordship. The letter seeking explanation also we have enclosed, Lordship, in our affidavit.
Yes, we've seen that.
My Lord, I have filed my rejoinder. If your Lordship kindly comes to page 13, my Lord, I will dispute, my Lord, my friend's submission that I have not joined. Annexure 8.
See Annexure 6 of the affidavit? He didn't. Why he didn't submit his joining report? See, this clarifies the point. In fact, invited reference that I have to honor informed Sri CN Thapa. This is from executive engineer to chief engineer came to the office after receiving the order, but didn't submit joining report. Since then, the report office anymore.
My Lord, thereafter, my Lord, your Lordship kindly comes to my reply. I have submitted one document which is available with my record with my in respect of my husband of my petitioner. Your Lordship will see Annexure A, page 13, certified that I have.
1 second.
Page 13, my Lord. Reply to my friend's affidavit, my Lord. It was on 14th of April 2000.
Certificate transfer of charge.
Yes, my Lord. And then I will take your Lordship to Annexure 15, Annexure B, page 15, also next page. (19th of November 2009), issued by the Under Secretary.
Yes. How do you explain this, Mr. Karmi? See, this 19 November 2009. He's a field officer.
My Lord, he retired as
he was a field officer only. I mean, he served, last posting was?
Moflang, my Lord.
The field officer only, I mean.
Lordship, this application for leave, it was given in while he was in Bajang Doba, Lordship.
That's 19 November 2009?
Yeah, it was while he was in Bajang Doba.
How do you say that?
Yes, Lordship, it is there.
Is Annexure B? 19 November 2009. Page 15 of their affidavit. You kindly see it.
This one.
This is Moplang.
But from the writ petition itself, Lordship, he applied leave while he was in Bajang Doba.
My Lord,
we'll do one thing. It seems there's some problem intra-department with your records from whether, see, one says that he's given his joining report, transfer of charge. This is dated 14/4/2009, correct?
Yes.
Relieving officer in This is he's relieving. Is not given who he relieved.
Yes.
Is in the Moplang. He took over. He came around 14/4/2009. Then 19th November 2009 he was given earned leave. That shows that means he was there in Moplang.
Till 13.
How does Bajang Doba come in?
The transfer order was on 13/10/2008. Transfer order to Moplang. 13/10/2008. But this is on the 14th of April 2009. After 1 year.
See what is happening here. See, now you come back to annexure 5, annexure 6, page 16 of your affidavit. See, you have to tie the pieces together. He came after received transfer order, correct?
Yes.
He didn't report office anymore after that.
Yes. He came only on 1 day, and after that he did not appear anymore. That is as per the affidavit also.
Your affidavit says that he came after transfer order, but he didn't give any joining report.
Yes, right.
But then this joining report is there 14/4, and from the records that means you have not been able to take out the joining report. This is 2016. There's a lot of incongruity. This is 2016, right, sir. Then it comes to annexure A of their wherever he's taken out from. That he's come on
14th,
and it's been given to the AG also copy.
There is no.
You have copy of this.
Signature only of the.
Exactly.
There is no counter signed by the office also.
From?
My lord, whatever document available with
where did you extract this document from?
This document was with my husband's file, my lord.
That means he didn't go and relieve.
There is no signature of EE also.
That also I inquired, and then I have not found any satisfactory answer, my lord.
In the official record does not exist.
Yes.
Does he have his service file still there with you?
Here in this case, Lordship, very unfortunate. The records are missing, Lordship, this year. But still, I'll have to, regarding this, I have to verify.
You expect this court then to what do you call it? To regenerate the record?
No, it's not that much.
This is a big, there's only one lacuna, that's the thing.
Well, only one small thing, your lordship.
You can't make a notional assessment of last pay drawn wherever you was posted before he was transferred to Moplang.
That is
whatever he was started working. When was he appointed initially?
Initially, I was appointed 1980 and was regularized in the year 1982.
Okay, that's fine.
20 years qualification.
20 years is
yes. Well, he has obtained the qualifying service.
Well, one small question to myself. Well, Annexure 5 to my writ petition. How come this order of superannuation has come? If they do not have any record, my lord, I'm just asking myself, my lord.
See, since they don't have records, that's the only thing.
Annexure 5, page 41.
What should we do, Mr. Kharmi? You take some instructions. Okay, take down.
Pass some effective order also, Lordship. Since they are saying that there's no.
Whether you can get any in the course of hearing.
Lordship, in this case, if I may just point out, I think maybe the record at the time when he was transferred to Moplang, it was not transmitted. It was not transmitted to Moplang, maybe.
Exactly. In the course of hearing, a question that has arisen is whether the writ petitioner had joined in his place of posting. That is GS Division number 2 Moplang, pursuant to the transfer order dated 13/10/2008. Stop. Though a document has been annexed, though a certificate of transfer of charge has been annexed, annexure. This is A to your rejoinder.
Well,
A to the rejoinder affidavit. The same is also questioned by the senior government advocate. Stop. In this view, the matter, the senior government advocate reads for and has allowed 2 weeks' time to obtain further necessary instructions as to service records. Because you have to try to locate them. Otherwise, we'll have the final order will be in 20 years. They've served 20 years.
Right.
Yes, after 2 weeks, you take it.
Obliged.
Item number 2.
May it please, Lord. Also, this is pension matter, Lord, and it's fixed for rejoinder affidavit from our part, Lord.
Your
So,
Lordship,
Lord, I'm praying for 2 weeks' time, Lord. To seek
Your Lordship, if I may point out, as per the last order, the petitioner was supposed to come with instructions.
What instructions we have?
Lordship, because they're saying that I'm not signing the papers, I'm not cooperating with them, Lordship. That I need to.
You're not cooperating with what?
With them when they ask me to sign on some papers.
Some documents have to be signed by the petitioner, Your Lordship, and he is not coming forward to sign these documents.
Lordship, as far as my instructions, Lordship, petitioner won, but then he was asked to sign on plain papers, blank papers.
Not true, Your Lordship.
So
that's instructions.
Lordship, that was the previous instruction which I get. So I need to seek more further instructions, Lordship.
His signature is required, Your Lordship,
Lordship,
to
he was
process
asked
the
to sign on
documents.
blank forms, Lordship, without any details. So kindly allow me 2 weeks' time, Lordship, to seek for further instructions.
I've enclosed the documents, Your Lordship, which
See,
require his
the only thing
signature.
is that you have to sign is like this, okay? It's a form.
Yes, Your Lordship. I've
It's a form
enclosed it.
option undertaking.
Yes, Lordship.
Go and sign it.
Lordship, I'll take instructions.
Tell them to
Lordship.
give a prepared format. Why have to sign a blank
Your
paper?
Lordship, the documents were provided to him only, like this,
It's
Your
a
Lordship.
form. It says blank.
Your Lordship, his details are in this form also, Your Lordship, which I've enclosed in my affidavit.
You print out the form, give it to him.
Lordship,
You sign it, take it to them.
Your Lordship, yes, if he comes to the office.
I'll see instructions and file rejoinder affidavit.
Yes, take down. Mr. Kitahar submits that several instructions that though the writ petitioner had gone to the office of the respondents, he was asked to put signature on blank paper, which he refused. Stop like MSZ in Onkanri has submitted that the petitioner is only to sign on the form of option with regard to statements fixation of that sorry, I'm not, but he submitted that it's on a form. It's a format of a form. So she prays that she may go obtain instructions for next day. How do you go? You instruct them with a form, let them print out the form.
Your Lordship, that has been done, Your Lordship, and he's been asked to come to the
that
office.
means you don't have a copy of the form with them, so you made them send blank paper.
No, Your Lordship, he refuses to come to the office, Your Lordship. That is just their
more
claim.
instructions, Lordship, because as far as my instructions
is permitted to obtain for the instructions. It's for your own good only.
Lordship, I understand.
The only case is that you pay no additional increment, that's all.
Your Lordship.
That's nothing, very small matter.
3.
Deeply obliged.
Well, I've received the affidavit filed by the respondent.
No rejoinder necessary.
Well, I'm praying for a week's time, my lord. Just a week's time is enough.
Yes, Mr. Papa prays for another 1 week's time to file rejoinder. The affidavit filed by respondent number
1 to 5. 1 to
1 to 5 and 8.
1 to 5 and 8. And 8 also.
Wait, please, Your Lordship. Your Lordship, I'm praying for 2 days' time to file my affidavit.
Yes, I've prayed for the 1 week's time allowed by affidavit by the state respondents.
Item 4 to 9 are connected, Your Lordship.
4 to 9, what's the matter about?
The RDA matter, Your Lordship. They're praying for regularization.
They are being paid, you're not being paid anymore, I think.
They are being paid, Your Lordship.
How?
Your Lordship, they have been allowed to continue, Your Lordship.
They're very lucky because the scheme's not there anymore.
Yes, Your Lordship.
Yes.
10. Obliged, Lordship.
Yes.
Please, Your Lordship, I have instruction, and then this matter can be closed, Your Lordship. We can defreeze the account.
What is the amount?
The amount is 1,50,000. Is the amount to be hold. You can disputed amount is 1,50,000 also.
You will close it. Who's the leading counsel?
So as per the writ petition, they are saying 8 lakhs.
That's your.
The prayer made, Your Lordship, at page 10, Your Lordship, to withhold 8 lakhs.
Now it's only 1 lakh, you say.
1,50,000 is the amount, disputed amount.
So there will be only 1,50,000.
Yes, sir.
Yes. We have any written instructions?
Yes, I have an email correspondent.
You kindly pass it over. Yes. Response number 3, correct?
Response number 3. 2.
Number 2 or 3?
2, Your Lordship.
3 is?
No, 3. You're number 3.
So you are paying for station head officer?
Sorry, Your Lordship. My apology, Your Lordship. 3, Your Lordship.
Yes. In this matter, where prayer has made for the freezing of the account with petitioner, for the freezing the account of petitioner and for retention only the lien amount. Mr. S. Marpan today has produced instructions that the disputed amount is of rupees
1,50,000,
and that is the only amount which will be kept in lien for the petitioner. The submission is noted and the communication dated 28/6/2026.
Yes, sir.
It's also Orus. Yes, stop. Next by your name, sorry.
Estapa, Lordship. Estapa.
Estapa. Mr. Estapa for the petitioner. The President of the petitioner also have no objections to submissions made by the Learned Counsel for the response number 3 bank stop. Next paragraph. However, noted that in their prayer, the petitioner stated that rupees 8 lakhs is the amount, which, however, as per submissions of the Learned Counsel for number 3 is only 1.5 lakhs. In that view of the matter, this matter is disposed of by allowing response number 3 to keep a lien on amount of 1.5 lakh and the account of the petitioner be frozen forthwith. Yes. As ordered above, matter stands closed and disposed of.
Lordship.
It is back.
11.
Please, Lordship.
State has filed the counter affidavit in terms of last order.
Also, I'm praying for 2 weeks' time, Lordship, to file the rejoinder.
What is the matter?
I'm seeking instructions, Lordship. This is regarding that election of this this Meghalaya State Pharmacy Council, Lordship.
Yes, Mr. Tidakar. On the petition pays for 2 weeks' time to file rejoinder. Yes.
My lords, I also seek time to file my affidavit, my lords.
Even for whom?
Registrar,
you already saw time last time.
Yes, my lords.
Should we close
As
it?
by way of last indulgence.
Who's number
my
4?
lords. Registrar, my lords.
Why you not filed it?
My lords, we've just received instructions late last evening.
Mr. Alkes, on behalf of which respondent?
1, 2, 3. 1, 2, and 3. I appear for 4, my lords.
To the affidavit filed by respondents 1, 2, and 3, Mr. Tidakar prays for until about 2 weeks' time to file rejoinder. Stop. Next 5 MSI Emily from number 4. However, sought further 1 week's time to file affidavit. Praise also allowed. Just after 2 weeks, yes.
Thank you, my lords. Much obliged. 12.
May it please, Your Lordship. Your Lordship, I'm praying for 1 week's time to file an affidavit.
Instructions are complete now.
Your Lordship.
MSZ Inongandy submits that instructions have since complete instructions have since been received. He prays for further 2 weeks' time for affidavit.
Your Lordship, the petitioners are yet to receive the salary, Your Lordship.
Yes, huh?
The petitioners are yet to receive the salaries, Your Lordship. They haven't
Why
released
review
it.
salary?
Your Lordship, we'll be filing an affidavit, Your Lordship,
Within
within
1 week. Within 1 week. Yes, interim orders need to continue. So we'll have it next week.
13 and 13 are connected matters, Your Lordship.
Obliged, Lordship.
14.
Okay.
14.
Yes, ready the matter?
My lord, there is a bereavement in Mr. Sujite's chamber. I'm aware of that. So.
Oh, it's a.
Yes, my lord. He's an officer, our officer, my lord. He has passed away, and he's the elder brother of one of the associates.
Yes, yes.
I was praying for disposal of this matter because we are taking. It's under process, but since my friend may have difficulty, I believe.
But then the service extended with 31st.
No, my lord, what happened here is that, my lord, there's a donation of land which was registered also, gift deed was registered. But apparently what happened, my lord, the procedure was not followed because in veterinary department what we have is that we have a guidelines, my lord. Like there is a procedure which has been framed by the government, particularly in veterinary department, that was not followed. So now there is a representation also, my lord, that has been enclosed. So by virtue of this representation, we are following the procedure, my lord, now. An inspection has to go. My lord, what happened?
No, one thing, see, you're concerned about what? See, Ms. Moni, that now it's a lady. Yes, her appointment.
Yes, my lord.
Having extended 31/8. Because matters taken beyond that will happen.
No, my lord, the petitioner
they
here.
will have it on when will he come back? On Friday?
Next week, Your Lordship.
On Friday? Next week, ordinary 24th.
Okay.
Then the engagement will get over on 31/8.
Friday then, Your Lordship.
Let it come on Friday.
My lord,
Yes, as it's reported that Mr. SD is in bereavement, let this matter appear on Friday.
15. They're supposed to file the affidavit.
We'll be filing our affidavit, Your Lordship.
You won't be filing?
Yes, Your Lordship.
You won't be filing, we'll be filing.
I'll be filing.
Can't hear you.
We'll be filing, Your Lordship.
You'll be filing?
Yes.
What about private respondent?
No private.
No private respondent, Lordship.
It's come first time. You have to chase with some brief follow up for the 2 week time for affidavit.
16. Lordship, this is also similar matter, Lordship.
Same.
Yes. Item number till 17, Lordship.
What is matters?
JCDC matter. Retirement benefits, Lordship.
Okay.
JCDC.
Yes, go see. Yes, Mr. So, what's your order?
Hang up, Lordship. 18. May I please, Your Lordship? I'm praying for some time, Your Lordship, to file our affidavit.
What about 5 and 6?
Lordship, I'm applying for 5 and 6. I already filed Wakalakama.
Mr. So, Mr. Your full name?
Mehtab Sarkar.
M. Sarkar. Yes. Mr. M. Sarkar entered appearance today on behalf of respondents 5 and 6 as such. Notice complete all respondents stuff. The prayer was allowed?
2 weeks.
2 weeks.
2 weeks time to file affidavit. Similar prayer made by MS Eilingwa, Judge GA 124. Copies further time. Both prayers allowed is after 2 weeks for affidavit.
19. May I please, Your Lordship, we took steps.
We are paying for 5.
I am paying for respond number 5, Your Lordship. I am entering my appearance.
E. Paske, as a appearance will be housed for number 5. As such, those complete all respondents. How much time for affidavit?
Your Lordship, I'm praying for 2 weeks' time. We're awaiting instructions.
Yes,
2 weeks' time, Your Lordship.
Yes, sir. Both the MS and the GA 4, 1, 2, 3. Ibi Pasa, with Ibi Pasa. She was here just now. What 1, 2, 3. And Mr. P. Paske for 5. Pray for allowed 2 weeks' time to file affidavit.
Obliged, Your Lordship.
20.
Deeply obliged, Your Lordship.
May I please, Your Lordship? Lordship, this is a fresh matter, hence require 3 weeks time to file an affidavit.
Yes, as paid for the 3 weeks time of affidavit is this thereafter.
Highly obliged.
21.
Please, Your Lordship, I have already taken steps for respond number 6 and 7, Your Lordship.
6 and 7.
Yes, Your Lordship.
1 second. Also indicates that service not complete on yet on response number 6 and 7. Stop. What do you want? Your file affidavit?
I think it is a purely civil disputed question of fact.
You file affidavit?
I'll take instructions on the matter.
Yes.
If required, allow me to file short of it.
Which is not like so. Another senior counsel so appearing for respondents number 1, 2, 3 submits that the matter involves disputed questions of fact. Yes. However, praise is allowed to put in a small affidavit. Yes. in this regard. The praise allowed. List after
2 weeks, Your Lordship.
2 weeks.
Your Lordship, I may be allowed to file the affidavit of service in the next date, Your Lordship.
For this after 2 weeks, stop. MS LD somewhere.
Team Marak, Your Lordship.
Sorry, is permitted to obtain series of service and file affidavit on the parent respondents.
Highly obliged, Your Lordship.
Yes,
Hearing, supplement 5.
Mr. Sen, the counsel wants a decent burial of the case. So you...
Lordship, this is a case, my lord. Why I say, my lord, this is connected with Ilyas Marvinian, Mr. D.K. Dotto is doing. It's a very brief history, my lord.
She said she's retiring today, but at the end of the month.
Yes, Your Lordship.
No, my lord, I have all sympathy, my lord, but then I have my limitation. Now, there are altogether, my lord, 12 temporary status employees. Now, under the scheme, they were eligible to be regularized, my lord. That is there.
Group D post.
Group D post. Now, in the meantime, what happened, my lord? That Group D post either upgraded or abolished, my lord. Now Group C post is there with higher qualification. Now it's not that we are averse to it, my lord. Because of this situation, we have written their 12 cases altogether. All of them are before your lordship. We have written their cases, my lord, to the UGC.
No, we are aware of that. Again, you don't have an authority to extend the scheme on your own accord. No, you only go on instructions. And MS Langstey has produced instructions also.
They said that we cannot.
That is what she wants. She wants a decent burial.
Yes, sir.
So far, my lord, that lordship has recently that regularization. There is also now before division.
No, I'm not on all this.
Yes. Because no, there is a cross. There was a
who produced order that yesterday who produced it? That order region.
Oh, yesterday.
Yes, my lord. But there was a cross appeal also. Cross appeal by the
new. But only thing is, your lordship. Only thing is that no upgraded is it is not now. It is in 2010. It is upgraded. D post is upgraded in 2010. And now my learned friend has come up in 25. They have come up with the document that it is Group D is abolished and Group. So they are unable to regularize.
Qualified for Group C.
Yes, they are not. But only thing is that, your lordship, even in 2000 also some documents are there. After 3 years of continuous service under temporary status, automatically they will be regularized in Group D post. So why is, your lordship,
automatically after 30 years?
3 years of continuous service. So they have gone since 93.
Okay, fine. That is fine. That's water under the bridge. Now suppose, okay, we're going to regularize you. Where will they regularize you? Where? Give the answer.
So
where will regularize you?
Group D is
in space. Then the Group D post not there anymore.
So it is not there regular.
So yes. So what are you going to do?
So vacancy is there, your lordship. He is driving a vehicle. So
vacancy is driving a vehicle of some other drivers. Now that doesn't mean the driver
is under transport department. All along, your lordship, he is attached to the transport department.
See, Ms. Bharatchaji, the very simple thing. Now he might have been entitled to some, relief earlier on, but then after the scheme is discontinued, and Nehu was bound by UGC directives, They have not extended also. No, they have, in the other case, they've given, I think Mr. Datta's case, right?
Yes.
Similar.
So I leave it to your discretion.
If you want to avoid this, we can list it together. With
No, Your Lordship, I will not be there, Your Lordship.
It doesn't matter.
No, Your Lordship. So I want it to be discussed, closed. Discretion of Your Lordship. Whatever it is, if it is, I am willingly, I'll accept it, Your Lordship.
Only thing, all sympathy, my lord. This kind, no, I'm not saying this. All sympathy. Our liberty. The one suggestion, my lord. I have given one suggestion. They could have challenged UGC's decision instead of going after it.
No, Your Lordship, what I am saying, Your Lordship, he is going to be retired, and Your Lordship is very much aware, because before retirement of 1 month ahead, everything should be clear, all documents should be clear. So during
So see, the things that they bring for notional realization, the pensionary benefits can be availed of. That's the only thing. They're temporary. Now, how many years you served?
Since 93, 91 to till date he's driving. Sometimes even Your Lordship, not only that, in the past also I have annexed some document, though I'm not showing in the agenda. In 2000 there was vacancy, Your Lordship. Vacancy and test drive.
Why did you come that time?
No, Your Lordship. So I do not know, because that I am also new, Your Lordship.
No, I'm sure. I'm not saying you.
You means
that,
no client, because they are very simple, Your Lordship. Class 9 passed. How we will expect that they should have come earlier? But his candidature was rejected, saying that you were unfit. But on the same day, Your Lordship, whole day he was allowed to drive the heavy vehicle, university bus. I have attached in my rejoinder, Your Lordship. I'm not taking all this. It's all right, Your Lordship. I am happy to accept if it is. Your Lordship may dismiss also, because I need closure, because 70,000 salary is not a small amount, and GPF 12,500. So whatever his
do you have any package at the end?
No, he will get
There's
it, Your Lordship.
Temporary status, my lord.
No problem fund, nothing.
It is some
Problem fund must be there.
Are there those benefit whatever under temporary?
You have to be getting EPF.
Because 2000
No EPF.
EPF, no, only
Impossible.
GPF.
GPF
is there.
GPF
they are
those benefit they will
contributing.
get.
GPF, because it is the 2000 letter, Your Lordship, notification of Nehu.
Tell me one thing, Mr. Sen. Now these temporary employees, are they covered under any health insurance scheme? No.
Health insurance. But so far, medical leave and other things they get. Like
They get, yes.
But then whether they covered under certain
except
medical
GPF,
insurance, at least a certain amount for a year, no, for any medical, they're not covered.
Medical leave and other things they get. GPF they get.
But then there's really
GPF is there. General.
Even house rent they are getting, Your Lordship. House rent also they are getting, and festival advance also getting.
Those other things, those benefits they get, but just like regular employees.
Just like
this is because provided in the scheme. They are treated almost for everything like a regular.
Everything treated like a regular. Only thing their designation is not there.
Taken away by them.
They are actually, Your Lordship, they are documented. Then affidavit is also just a few lines, nothing. And she is just representing. She is not the properly appointed. I don't know whether she is properly appointed or not.
By whom?
Because by the UGC. Because earlier Puja was there.
Now you're challenging her.
No, I am not challenging, Your Lordship. I am not challenging. I'm just arguing on behalf of my client only. Nothing. I am not challenging nothing. So their affidavit also said nothing, that it is just one line. It is not since it is a stop and they are not covered under the scheme. Scheme is gone, boss. But they are treated as per their payslip, Your Lordship. Can you have a just 1 minute look at their pay scale, Your Lordship? Payslip 53, page number 53, Your Lordship.
He'll come earlier on, 18.
Yes.
What is the order there?
No, order.
Yes. Petition dispose the direction respondent. So where is the disposal order of your representation?
Representation, yes, Your Lordship.
Pursuant to the order dated 23/5/2018. Where is it?
Yes, 23. It is at page 25, annexure 8 of my annexure 8, page 25 of my deed petition, Your Lordship.
25.
23/9/20. One is 24.
Where, which page, kindly?
One is 25, Your Lordship. Kindly have a look at.
Page 25. 25 is. How come page 25 is missing from you?
25, 26, my.
26 is representation.
Yes, 27.
Where's the order? Where's the order?
Oh, order, yes. It is at page 27, Your Lordship. 27 order, rejection order, no, Your Lordship. It is page 27 of writ petition, Your Lordship. 27, 1, 20, 25.
Yes. Take down. By this second round of litigation, the writ petitioner is before this court praying for directions for regularization of service against regular vacancies and for all other consequential benefits. Stop. By way of the earlier petition being LPC number 93 of 2017, this court, by order dated 23/5/2018, had disposed of the same with a direction to the respondents to consider the case of the petitioner in accordance with the scheme, which is the capital G grant of capital T temporary status and regularization scheme, R capital S scheme, and to pass final orders therein. Next paragraph. MSS Barachaj United Counsel with petitioner submits that pursuant to the order of this court, the matter was reconsidered by the respondent university, who, however, by letter dated 27/01/2025 had regretted the prayer in view of the fact that the casual laborers C capital L capital within bracket grant of temporary status and regularization close bracket scheme Government of India 1993 was not applicable to the university, which is an autonomous organization under the Department of Higher Education. So, Leonard Counsel submitted that this scheme, when was it discontinued?
This D post has been abolished after the 6th CPC by communication dated by 2010.
You submitted that the petitioner has served how many years?
33, 34 years, Your Lordship. 91 to.
He joined
in.
Has served as a casual temporary. As a casual employee for the past since 1991.
Casual because he was.
And has been allowed and has been given all the trappings of regular service.
Your Transport Department.
trapping the regular service means you've given your HRA, you know, which includes certain service benefits. So, she therefore prays that, notwithstanding the inapplicability of the scheme to the case of the petitioner, the respondents be directed to consider a case favorably. Also, in view of the fact that the petition is due to superannuate on
2/10/2026.
Oh, in October. I thought next week.
Next month. I said after next.
That's not next month. It was September 1. 2/10.
2/10.
2/10/2026. Next paragraph. Mr. S.N. Leonard, counsel on behalf of respondents number
3 and 4. Respondent number 3 and 4, Mr.
3 and 4. In reply, has submitted that though the respondent university is sympathetic to the plight of the petitioner, but in view of the
this communication is not on record, it is in other read petition. This is in other Mr. Doctor's case. I have filed a detailed affidavit. All the cases were referred with a copy to on the back end to the UGC.
This UGC 1998 extended to how many years?
Hello.
See, anyway, yes, sir. But in view of the restrictions, were unable to consider his case. In this context, reference has been made by the counsel to a clarification on regularization of temporary status casual workers working in Nehu dated 06/02/2023. Come on. Wherein he submits that the Government of India in the Ministry of Personnel, Public Grievances Pensions by Office of Memorandum dated 16/10/12/14 had, but he was, see, 1991, why is the case not sent in that time when the scheme was still operating?
No, but it's from 93, all right, Your Lordship.
Yes, no, why was the case of petition not sent then?
Petition,
of course, that's just, we can't do it just like post-mortem, but why?
Yes, I'll just give an explanation, Your Lordship. Normally, my Lord, this 93 is a one-time scheme. So this should have been done, and this was extended to the university only in 98. This is a central government scheme. UGC extended in 98. So all these cases should have been over within 4-5 years. Did not happen, my Lord. Why happened? But there were some technical cases where they are short by a few days. And those who were short by a few days, they came very late before the court, my Lord. And only it is only at the intervention of the court, my Lord. The court is generously and all, my Lord. Repeated orders were passed, my Lord. We have done it. We have granted them the temporary status. Now, my Lord, so far Group D post, my Lord, since it has been abolished, we have referred it to them along with the High Court's order. Their case has been, my Lord, they have been conferred because of the intervention of the court. Otherwise, in normal rules, perhaps they would not have got even the temporary status.
But Your Lordship, one more thing. They are saying Nehu is a autonomous body, that's why. But their ID card shows that issued by central.
No, that has no meaning. They are, of course, Nehu has been a central act. It
Central.
stands on its own footing, yes. It's an autonomous body. Even Mr. General's company, NIPCO, also autonomous.
Yes.
It, it,
So
all
they have their own.
directions of the government won't apply totally until the board accepts those or incorporates them. Same thing when unless they get orders from UGC, how will they on their own?
But your lordship, it is a document annexed
You
by.
can't make these kind of submissions.
No, because if there is any vacancy, university can pull from the temporary for regularization.
Where is that?
It is this.
Petition, where is it?
Not petition. It is
Then?
annexed by Mr. Sen in affidavit in opposition. Your
Where
lordship,
does it say?
annexed 22nd April 1998.
Where is that?
Just prior to 6/2 because
Yes.
because
Where?
because your lordship, this affidavit is this case Mr. Sen has filed only one affidavit for all cases saying that they are similar, but it is not similar. We'll have to go through in between the line, your lordship.
You don't see these additional persons. They could pull vacant posts and
Yes,
fill
sir.
it,
Yeah.
the required position.
Yes, your lordship.
This who's that? It's not Nehu letter, this one.
Yes, it is by the issued by the Undersecretary to the Government of Meghalaya.
This is by UGC.
UGC, man.
It's not a letter.
Undersecretary
It's not a letter.
UGC. Not university.
But it is attached in the affidavit filed by this.
They have extended it, my lord. That's how we have adopted it.
My lord, if I may submit, my lord, we have already argued these points before in our previous hearings. My learned senior Mr. Datta was there and we have clarified all these from our end.
Is retiring when? October? I thought it's this week. We'll listen together with that better. But they'll have an impact on this.
No, your lordship, your lordship.
No, please. It's not a market that you bargain.
Same issues,
It's as this, we score it out. I thought it was retiring next week. You want
Not next week, your lordship.
You're not here also, no problem. We'll dispose it off. In the course of hearing, as reported that the petitioner will retire only on 2nd of October.
2nd October 2020.
Yes, this is a matter with other connected matters. When is it coming up?
Monday.
It's Monday. Yes.
Monday.
We're wasting the food time otherwise.
Oblige, man.
That's good.
My lord, this writ petition no longer survives as no offence stated established by the accused as per Tribunal Order 2726. I refer last order of this Honorable Court 15726.
Yes. Yes.
So.
Yes.
But this is the case where, my lord,
he wants only the penalty and the punishment to be set aside.
Yes.
No, my lord, he's relying on the order passed by Sestate.
Yes.
Sestate is 2726.
Yes.
My lord, this order is still under examination, my lord.
How long will you examine it?
It's only July's order, my lord. We are in August now, my lord. Last month's order.
After 1 week.
And otherwise also, my lord, otherwise also,
we'll close it.
Otherwise also, they should go to
orders,
they should go to Sestate, my lord, rather than come to High Court, my lord.
Why?
Because we file a
no penalty be imposed on prime members.
My lord, they should have filed appeal, all of them, my lord. Only one person goes on appeal, my lord. Others, they don't go on appeal.
They're just ancillary.
My lord, they are seeking some ancillary execution from this honorable court, my lord. Because,
Yes,
if you file appeal against that, my lord.
That the order passed says that dated
2726.
2726 examination. He prays for about 1 week's time to obtain specific instructions.
1 week, a little longer.
Okay, 2 weeks.
Okay. Much obliged.
33.
Yes, where's MSS Lamba?
My lord, she was supposed to join through PC.
This is a hypertension matter, my lord. Now they place reliance on certain guidelines which say that in case of hypertension, the candidate has to be admitted in hospital for 2 days and monitoring is done. It appears from the instruction I have received, monitoring was done for 2 days, my lord. but there's nothing that he was admitted into.
Where's Lamba?
Monitoring was done for 2 days, my lord, and
Where is the option?
consistently he was suffering from hypertension.
Yes.
I'll place it.
No, where's the instruction?
Yes.
Give her to him. Give that to him. Let her transmit it. Yes, sir. Give a copy to the petitioner. Yes, Dr. Mozia has produced communication in 21 July 2026 that states that the petitioner was kept under observation as prescribed by what?
By the guidelines, sir.
By the guidelines. The copy of the communication made over to the counsel for the petitioner just after 1 week. Yes. Yes. We just transmitted to her.
35.
Much obliged.
Much.
My lord, conducting counsels on legs, my lord.
Any interim orders are operating?
Yes, ma'am.
Yes. And the selection process was stayed.
Now, the simple question here is, your selection process not selected, impugning a fresh selection process. That's your case,
Yes,
correct?
that's the question. That's the question. We can take it to.
We can take it tomorrow also.
Tomorrow?
I have no problem.
Some urgency is there?
Urgency is there, Your Lordship.
We can take it tomorrow.
Yes, as the contacting counsel of the petition, Mr. Beechan, please the matter be taken up tomorrow.
Not my name, Dad.
Oh,
I'm
sorry. No, it came from your mouth tomorrow.
Sir, let it be on 26. Because tomorrow we have a Nokma matter that continuing.
Which way?
No, tomorrow is 19. Oh, sorry, 19. It's okay tomorrow.
Tomorrow, man.
Not tomorrow.
Tomorrow.
Tomorrow.